warmly welcome today's guest, Advocate Shilpa Joshi, ma'am. I welcome Chairman, Vice Chairman, and all the members of Bar Council of Maharashtra and Goa. And last but not the least, I welcome all the participants who are participating in today's lecture series. I would like to introduce Advocate Shilpa Joshi, ma'am, who has completed BSc in Microbiology from Nagpur. She has completed LLB and LLM from Mumbai University in year 1995, first part in Law of Crimes and second part in Consumer Protection Act. Ma'am started her practice in Mumbai since the year 1994 with her father-in-law, Advocate M.K. Joshi sir, who was an esteemed lawyer practicing in Bombay High Court, having experience of all the civil matters and rent act matters and matrimonial matters. She started her independent practice dealing with the matter under rent act and matrimonial matters. She since 2002 she is dealing with the matters arising under Domestic Violence Act and able guidance of senior advocate A.S. Khandekar sir. She has also conducted numerous matrimonial in the Mumbai University, Mumbai Family Court, and appeared in Honorable High Court. She has worked as a mediator in Mumbai Family Court since 2011 and have settled many matrimonial disputes. Thank you, ma'am, for giving me such opportunity. Over to you, ma'am.
Thank you. Can I start? Can you hear me?
हाँ मॅडम आवाज येतोय आपला.
येतोय आवाज?
हा येतोय.
स्टार्ट करू शकतो?
स्टार्ट हो.
Good evening, everyone. Respected Chairman of Bar Council of Maharashtra and Goa, Shri Ghadge Sahib, Vice Chairman Dr. Uday Varunjikar, Advocate Jay Bhave, members of Bar Council of India, and all members of BCMG. I thank you all for the opportunity given to me for participating in this online lecture series. The topic today is cruelty as a ground of divorce and how it is to be proved in a divorce petition. Now, as lawyers and judges practicing matrimonial law, we come across the word cruelty and its connotations on a regular basis. The Hindu Marriage Act of 1955 or the Special Marriage Act of 1954 contains an identical ground for divorce, that is cruelty after the solemnization of marriage. The provision for divorce on the ground of cruelty is provided in section 13(1)(IA) of the Hindu Marriage Act and section 27(1)(D) of the Special Marriage Act. So let us see what section 13(1)(IA) speaks about. Any marriage solemnized, whether before or after the commencement of this act, may on the petition presented by either the husband or the wife be dissolved by a decree of divorce on the ground that the other party has, after the solemnization of the marriage, treated the petitioner with cruelty. The similar provision is there under section 27(1)(D) of the Special Marriage Act. So the word cruelty used in the act means physical as well as mental cruelty. Now, the word cruelty is not defined under any of the marriage laws. Cruelty simpliciter is the ground for divorce. So let us see the dictionary word cruelty. Now, the dictionary word cruelty is defined as the quality of being cruel, disposition of inflicting suffering, delight in or indifference to another's pain, mercilessness, hard-heartedness. Now, this is a dictionary word. If we see the term mental cruelty, as has been defined in the Black's Law Dictionary, which is as under mental cruelty as a ground of divorce, one spouse's course of conduct not involving actual violence that creates such anguish that it endangers the life, physical health, or mental health of the other spouse. This concept of cruelty has been summarized in Halsbury's Laws of England also. The general rule in all cases of cruelty is that the matrimonial relationship must be considered, and that rule is of special value when the cruelty consists not of violent acts but of injurious reproaches, complaints, accusations, or taunts. For it is the effect of the conduct rather than its nature which is of paramount importance in assessing the complaint of cruelty. So, whether one spouse has been guilty of cruelty to the other is essentially a question of fact, and previously decided cases have little, if any, value. The court should bear in mind the physical and the mental condition of the parties, as well as their social status, and should consider the impact of the personality and conduct of one spouse on the mind of the other, weighing all incidents and quarrels between the spouses from that point of view. Cruelty is a conduct which is complained of, and whether such conduct which is complained of is cruelty or not will be determined on the facts and circumstances in each case. Can everyone hear me?
मॅडम तुमचा आवाज एकदम क्लिअर आहे, काहीच प्रॉब्लेम एकदम
नाही आहे ना?
व्यवस्थित आहे. येस.
Okay. Now, cruelty need not be physical cruelty. Even without any physical assault, there can be cruelty which is called mental cruelty. What constitutes a cruelty may be interpreted in different ways, considering the social status, educational qualifications, economic status, family background, etc. Now, the general rule in all cases of cruelty is that the entire matrimonial relation must be considered before the court comes to a conclusion that cruelty has happened. This is especially important in cases when the cruelty alleged is not of violent acts but is mental cruelty. Now, let us go to the judicial precedents to understand what is cruelty. Now, judicial precedents have given the definition of what would be a conduct which amounts to cruelty. Thus, the conduct of the spouse against whom the cruelty is alleged should be of such character as to have caused danger to the life, limb, or health, bodily or mentally, or which gives rise to a reasonable apprehension in the mind of the other spouse that it would be harmful or injurious to live with the other spouse, and such conduct, if proved, amounts to cruelty. Cruelty which is necessary for passing the decree of divorce, because it is one of the grounds of divorce, and it is one of the grounds which has been frequently used. Most of the petitions in the family court are based on cruelty, mental or physical, has to be gathered from the evidence on record. The instances has to be clubbed together, and the reasonable inference has to be drawn whether the behavior of the spouse comes under the term cruelty or not. Now, let us see some history. Prior to the amendment of 1976, cruelty was only a ground for judicial separation and not a ground for divorce. Therefore, prior to 1976, it was required to prove cruelty so as to cause reasonable apprehension in the mind of the petitioner that it will be harmful or injurious to the petitioner to live with the other party. However, as per the 1976 amendment, only cruelty is required to be proved, since the adjectival phrase to cause a reasonable apprehension in the mind of the petitioner that it will be harmful or injurious to live with the other party is dropped from section 13(1) IA of the Hindu Marriage Act. So now, when you are aspiring to be family court judges, what the court has to do in a case of cruelty, the court has to come to a conclusion whether the acts committed by the other spouse amounts to cruelty, and it has to be assessed based on the facts of each case. Now, cruelty is not defined in the matrimonial laws. However, it is contemplated as a conduct of such character or such type which endangers the living of the petitioner with the respondent. The matrimonial law basically does not define cruelty, most probably because the legislature in its wisdom has refrained from defining cruelty so that the conduct alleged for cruelty covers all actions of men and women which are so diverse and infinite to cause cruelty, which can be included in the term cruelty. So the basic consideration while granting a divorce would be whether the petitioner can reasonably be expected to live with the respondent, or it would be dangerous for a spouse to live with the other. And it has to be based on circumstances of each case. Now, the apex court has dealt with both kinds of cruelty in different judgments. Now, the most important judgment would be Dastani versus Dastani. The other judgments which deal with cruelty, basically, or landmark judgments, are Samar Ghosh versus Jaya Ghosh, then Naveen Kohli versus Neelu Kohli. Now, the above judgments deal with cruelty as also some of them, Sangamitra Ghosh versus Kejal Kumar Ghosh. Some of them are also on irretrievable breakdown of marriage. But today we will confine ourselves only on the topic of cruelty and how it can be proved or how it should be proved in a matrimonial matter. Let us turn to the landmark judgment of Dastani versus Dastani, which is reported in 1975 to SCC 326, decided on 19th March 1975. So it is a pre-amendment when cruelty was only a ground for judicial separation. Here we get the guiding principles of cruelty and the burden of proving it. It has been held that the burden must lie on the petitioner to establish his or her case. For ordinarily, the burden lies on the party which affirms a fact and not on the party which denies it. The petitioner must therefore prove that the respondent has treated him with cruelty within the meaning of the section of the Act. The belief regarding the existence of a fact must be founded on a balance of probabilities. As a prudent man, so the court applies this test for finding whether fact in issue can be said to be proved. The first step in the process is to fix the probabilities. The second, to weigh them, though the two may often intermingle. The impossible is weeded out at the first stage, the improbable at the second. Now, within the wide range of probabilities, the court has often a difficult choice to make, but it is this choice which ultimately determines where the preponderance of probability lies. The test to apply is whether on a preponderance of probabilities, the relevant fact is proved. So in any matrimonial matter, the test is preponderance of probabilities. Considering that proceedings under the Act are essentially of a civil nature, the word satisfied. So how far the court should be satisfied? The court should be satisfied on a preponderance of probabilities and not satisfied beyond a reasonable doubt, which is a consideration in any criminal trial or in a criminal matter. Now, what is the inquiry which the court should do? The inquiry, therefore, has to be whether the conduct charged as cruelty is of such a character as to cause in the mind of the petitioner reasonable apprehension that it will be harmful or injurious for him to live with the respondent. So what is the conduct charge? That it should cause in the mind of the petitioner, the conduct of the other party, it should cause a reasonable apprehension in the mind of the petitioner that it will be harmful, that he or she cannot live with the other spouse. And if she continues to live or he continues to live, it will be harmful or injurious or dangerous for him to live with the respondent. So therefore, if we see section 10(1)(b), this is from Dastani versus Dastani, which is a pre-amendment, pre-1970. It is a judgment of 1975. So the word used is harm or injury to health, reputation, the working career, or the like would be an important consideration in determining whether the conduct of the respondent amounts to cruelty. Plainly, what must be determined is not whether the petitioner has proved the charge of cruelty, having regard to the principles of English law, but whether the petitioner proves that the respondent has treated him with such cruelty as to cause reasonable apprehension in his mind that it would be harmful or injurious for him to live with the respondent. Cruelty, which is a ground for dissolution of marriage, may be defined as a willful and unjustifiable conduct of such a character as to cause danger to life, limb, or health, bodily or mental, or as to give rise to a reasonable apprehension of such danger. Now, effect of cruelty on the aggrieved. The question whether the misconduct complained of constitutes cruelty and the like for divorce purposes is determined primarily by its effect upon the particular person complaining of the act. The question is not whether the conduct would be cruel to a reasonable person or a person of average or normal sensibilities, but whether it would have that effect upon the aggrieved spouse. That which may be cruel to one person may be laughed off by another. And what may not be cruel to an individual under one set of circumstances may be extreme cruelty under another set of circumstances. So basically, the conduct which is alleged of, that it differs from person to person. It differs from, it is dependent on the facts of each case. The inquiry, therefore, has to be whether the conduct charged as cruelty is such a character as to cause in the mind of the petitioner a reasonable apprehension that it would be harmful or injurious for him to live with the respondent. The second judgment which I am referring to is Samar Ghosh versus Jaya Ghosh, 2007, 4 SCC 511. Again, the same thing. The apex court has held that mental cruelty is a ground of divorce, nature and scope, non-susceptibility to comprehensive definition, approach to be followed by the court in determining the question of mental cruelty, held there cannot be any comprehensive definition of mental cruelty within which all kinds of cases of mental cruelty can be covered. No court should even attempt to give a comprehensive definition of mental cruelty. The court further says, the apex court further says, there can never be any straight jacket formula or fixed parameters for determining mental cruelty. The prudent and appropriate way to adjudicate the case would be to evaluate it on its peculiar facts and circumstances while taking the various factors mentioned herein into consideration. Again, the apex court says the concept of mental cruelty cannot remain static. It is bound to change with the passage of time. Impact of modern culture through print and electronic media. What may be mental cruelty now may not remain mental cruelty after a passage of time. So the apex court is aware of all these considerations, of all the changes which happen in society. So therefore, they say no uniform standard can be let down for guidance, yet some instances are indicated. So few instances I will take. On consideration of the complete matrimonial life of the parties, acute mental pain, agony and suffering, as would not make it possible for the parties to live with each other, would come within the broad parameters. Then what will not be mental cruelty? They say mere coldness or lack of affection cannot amount to cruelty. But frequent rudeness of language, if there is a continuous abusive language which is used, petulance of manner, indifference, neglect, may reach such a degree that it make the married life of the other spouse absolutely intolerable. Again, the apex court says mental cruelty is a state of mind. The feeling of deep anguish, disappointment, frustration in one spouse caused by the conduct of the other may lead to mental cruelty. A sustained course of abusive and humiliating treatment calculated to torture or render miserable the life of the spouse, sustained unjustifiable conduct, then sustained reprehensible conduct, indifference or total departure from the normal standards, causing injury to the mental health, will also amount to mental cruelty. Apex court further says the conduct must be much more than jealousy, selfishness, possessiveness, which cause unhappiness, but which may cause emotional upset, but may not be a ground for grant of divorce on the ground of mental cruelty. Now, mere trivial irritations, quarrels, normal wear and tear of the married life, which happens in day-to-day life, would not be adequate for the grant of divorce. The apex court further says our married life should be reviewed as a whole. So therefore, there has to be, whenever we draft a petition or whenever we want the court to believe that the cruelty has happened, there has to be a long chain of incidents and it has to be drafted in detail. All the instances have to be given. Only then the court can come to a conclusion that cruelty has happened. The ill conduct must be only merely saying that I have been treated with cruelty is not you will never get a divorce. So the conduct has to be established. The ill conduct must be persistent for a fairly lengthy period where the relationship has deteriorated to an extent that because of the acts and behavior of a spouse, the wronged party find it extremely difficult to live with the other party, may amount to mental cruelty. Now, unilateral decision of refusal to have intercourse for a considerable period without there being any physical incapacity or valid reason amounts to mental cruelty. Unilateral decision of not to have children amounts to either spouse amounts to mental cruelty. Then the court further says, where there has been a long period of continuous separation, it may fairly be concluded that the matrimonial bond is beyond repair. Marriage becomes a fiction, though supported by a legal tie. By refusing to sever the tie, to break the tie, the law in such cases does not serve the sanctity of marriage. On the contrary, it shows scant regard for the feelings and emotions of the parties. In such situations, it may lead to mental cruelty. In Shobharani versus Madhukar Reddy, again the apex court had an occasion to examine the concept of cruelty. And it says that the word cruelty under section 13(1) IA is used in the context of human conduct or behavior in relation to or in respect of the matrimonial duties or obligations. It is a course of conduct of one which is adversely affecting the other. The court further says the cruelty may be mental or physical, intentional or unintentional. If it is physical cruelty, it is a question of fact and degree, easy to prove, comparatively easy to prove. If it is mental cruelty, the inquiry must begin as to the nature of the cruel treatment and then as to the impact. So first inquiry is about the nature of the treatment and then as to the impact of such treatment on the mind of the spouse and whether it caused reasonable apprehension that it would be harmful or injurious to live with the other. Ultimately, it is a matter of inference to be drawn by taking into account the nature of conduct and its effect on the complaining spouse. So a lot of emphasis is given on how the courts should deal with mental cruelty. The court dealing with the petitions for divorce has to bear in mind that the problems before it are those of human beings. And these psychological changes in the spouse's conduct should be borne in mind before disposing of the petition for divorce. However insignificant or trifling such conduct may be, it may cause pain in the mind of another. But before the conduct can be called cruelty, it must touch a certain pitch of severity. It is for the court to weigh the gravity. And believe me, it is not an easy task. It has to be seen that the conduct is such that no reasonable person would tolerate it. The last judgment which I am referring to over here is Vinita Saxena versus Pankaj Pandit. What the apex court has said, I will refer to it in a... The apex court has observed as to what constitutes cruelty for the purpose of the said provision will not depend upon the numerical count of such incidents or only on the continuous course of such conduct, but really go by the intensity, gravity, and the stigmatic impact of it when meted out even once. So it is not a numerical count. Even meted out once could be enough. And the deleterious effect of it on the mental attitude necessary for maintaining a conducive matrimonial hope. So even once, it is enough. If you remember the movie Thappad, even once slapping by the husband is enough. It will amount to mental cruelty. If it has the effect, what is contemplated by the judicial precedents as cruelty. Now, we have seen what is cruelty. So let's now go to the next topic, next part of the lecture, at how to prove it. Now, proving cruelty in a divorce petition and the provisions of the Indian Evidence Act. Even though Section 14 of the Family Court Act states that the family court may receive in evidence any report, statement, documents, information that may, the word used is may, in its opinion, assist it to deal effectually with a dispute, whether or not the same would be otherwise relevant or admissible under the Indian Evidence Act. Still, in a trial in the family court, under the provisions of Indian Evidence Act are to be followed, and a complete go-by cannot be given as it would lead to failure of justice. Now, having understood what cruelty is in a matrimonial petition, let us see how it has to be proved and how it can be proved. Now, the initial burden of proving cruelty is on the petitioner who files the petition on the ground of cruelty. Merely by stating that the other spouse has treated me with cruelty is not enough to prove it. Mere statement that I have been subjected to cruelty, as I said earlier, is not enough for a decree of divorce to be passed. This is the practical aspect of it. Now, in any marriage, most of the incidents or the conduct which one spouse is narrating, these incidents happen behind closed doors. And there cannot be a direct or documentary evidence available for such incidents or conduct. Therefore, the question arises as to how to prove cruelty or what happens in a divorce petition. It is a word against word. In a divorce petition, which is when it is filed by the petitioner, mere statement is not enough, and therefore the divorce petition has to be based on the conduct of the other spouse. The oral testimony of the petitioner is the most important piece of evidence in a divorce petition. There has to be a consistent narration of the acts, of the incidents, which has caused an impact on the mind of the petitioner for him or her to file a petition for divorce. There is no scope for afterthought. So whatever incidents have taken place and whatever has happened till you file the petition, what has prompted you to file a petition, or what has brought you to the stage to file a petition, to go to the court of law and file a petition on the ground of cruelty, all that has to be narrated. Thus, when we apply the rules of evidence in a divorce petition, evidence can be of two types: oral evidence and documentary evidence. The oral evidence is the evidence which is given by the witness by way of examination in chief, and which is of course subject to cross-examination, and much depends on how he or she withstands the cross-examination. The oral testimony has to be on the relevant fact in issue. So Section 5 of the Indian Evidence Act says the relevancy of the facts. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue, and of such other facts as are hereinafter declared to be relevant, and of no others. What is a fact? Now, fact means and includes anything, state of thing, relation of things capable of being perceived by the senses, or mental condition of which any person is conscious. What is the illustration? There are certain objects arranged in a certain order, in a certain place, is a fact. That a man heard something or saw something is a fact. That a man said something, that a man said certain things is a fact. That a man holds certain opinion, has a certain intention is a fact. Acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation is a fact. That a man has a certain reputation is a fact. So in a given case of cruelty, the conduct of the spouse of calling the wife a doormat, illiterate, selfish woman, not taking care of the family is a fact which is relevant to decide whether such act amounts to cruelty or not. Then we go to the next. One fact is said to be relevant to another when one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of facts. What is a fact in issue? The expression fact in issue means and includes any fact from which, either by itself or in connection with the other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. So A is accused of the murder of B at the trial. The following facts may be an issue: that A intended to cause B's death, that A had received grave and sudden provocation from B, that A at the time of doing the act which caused B's death was by reason of unsoundness of mind, incapable of knowing its nature. For cruelty, what would be a fact in issue? If a wife has a suspicious nature and she suspects every action of the husband, the fact that she called his office colleagues to make inquiry about the whereabouts of the husband, passed some remarks in a bad taste against some female colleagues, went unannounced to the office, made some remarks at the security gate, are all facts which are relevant to prove the nature and conduct of the wife, which according to the petitioner is of a suspicious nature and which has impacted him. These facts are facts in issue. For cruelty in a divorce petition. Now we go to the next. Oral evidence and documentary evidence. So what do we mean by document? We'll take it in brief. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means intended to be used or which may be used for the purpose of recording that matter. In a matrimonial matter, documentary evidence could be letters, emails, WhatsApp messages, photographs, video recordings, medical documents, and much more. So now let us see what is evidence. So evidence means and includes, what is the definition of evidence? All statements which the court permits or requires to be made before it by witnesses in relation to the matters of fact under inquiry. Such statements are called oral evidence. So evidence is oral evidence or documentary evidence. All documents including electronic record. In today's times when the society has changed so much, the electronic evidence or electronic records play a very important role in a matrimonial trial. We all know that. All documents including electronic records produced for the inspection of the court. Such documents are called documentary evidence. Now let us see what is proved, what is disproved and what is not proved. What is proved? A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So the court in a divorce petition, after considering the chain of events, incidents narrated, or after considering the facts in its totality, thinks it probable to have happened, then the fact can said to be proved. In a divorce petition, when the petitioner narrates the unreasonable conduct since the beginning of the marriage till the filing of the petition as to the happenings in the married life, the fact of cruelty could be proved. Disproved, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Not proved, a fact is said to be not proved when it is neither proved nor disproved. We have section 4, presumptions. May presume, shall presume, conclusive proof. May presume, that whenever it is provided by this act that the court may presume a fact, may either regard such fact as proved unless and until it is disproved, or may call for a proof of it. Shall presume, whenever it is directed by this act that a court shall presume a fact, that there is a law which says so. So, shall presume a fact, it shall regard such fact as proved unless and until it is disproved. Conclusive proof, when one fact is declared by this act to be conclusive proof of another, the court shall, on the proof of the one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Now, the next important thing, how evidence is recorded or how the evidence is to be given in regard to the matrimonial matters. We again see section 5. Evidence may be given of facts in issue and relevant facts. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. Section 6, relevancy of facts, forming part of same transaction. Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. When we are talking about evidence, we go to the opinion, section 45, opinions of expert. When the court has to form an opinion upon a point of foreign law or of science or art or as to the identity of a handwriting, the opinions upon that point of persons specially skilled in such foreign law, science or art are relevant facts. Such persons are called experts. We can take help of expert opinion in a divorce petition based on the ground of cruelty. Then we have 45A, opinion of examiner of electronic evidence, which is also a very important provision. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence is a relevant fact. Then we go to sections 58, 56 to 58 on proof. Which facts need not be proved? Which facts the court can take judicial notice, and the facts admitted need not be proved. Then section 59 deals with oral evidence, which is the most important thing. Proof of facts of oral evidence. All facts except the contents of documents or electronic records may be proved by oral evidence. If when we conduct a trial, if a document is there, we always say a document, you need not prove it. If the document is already proved, you need not give. The document will speak for itself, because it is our assumption that men may lie, but document will not. Section 60. Oral evidence must be direct. Oral evidence must in all cases, whatever be, direct, that is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. If it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense. If it refers to an opinion or to the ground on which that opinion is held, it must be the evidence of the person who holds that opinion. So this is oral evidence. The other part is documentary evidence. The contents of documents may be proved either by primary evidence or by secondary evidence. What is the primary evidence? Section 62. It means the document itself produced for the inspection of the court. Original document. Section 63, secondary evidence. What is secondary evidence? That is given in section 63. Certified copies, copies made from the original, copies made from or compared with the original, so and so, oral accounts of the contents of a document. Now, section 64 says proof of document by primary evidence. Documents must be proved by primary evidence except in the cases hereinafter mentioned. So section 65 deals with secondary evidence relating to documents. So section 65 and 66 are connected. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, if the original is not in your custody and it is in the custody of the other person, you have to give him notice under section 66 to produce the original. On the failure to produce the original, the Xerox can be marked by the court. Or if the original is destroyed or lost, when the original is of such a nature as not to be easily movable. So all those criteria are given when secondary evidence of a document may be allowed. Then we have section 65B, the admissibility of electronic records. So we give a certificate under section 65B whenever there is an electronic record. The format is given in the act itself. Then we come to section 101, burden of proof. Now, whoever desires any court to give any judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Section 102, on whom the burden of proof lies. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Burden of proof as to particular fact. The burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is proved by any law that the proof of that fact shall lie on any particular person. Section 104, burden of proving fact to be proved to make evidence admissible. The burden of proving any fact necessary to be proved in order to enable any person to give evidence is on the person who wishes to give such evidence. Then we go to the next provision, that is section 137, which is examination in chief, because we are on the topic cruelty and how it is to be proved in a matrimonial court. So section 137, examination in chief. The examination of a witness by the party who calls him shall be called his examination in chief. Cross-examination. Examination of a witness by the adverse party is called as a cross-examination. Re-examination. Examination of a witness subsequent to the cross-examination by the party who calls him shall be called as re-examination. 138 gives orders of examination. So the witness has to be first examined in chief. Then if the other party desires, cross-examined, then re-examined if necessary. Now again, the examination and cross-examination must relate to relevant facts. But the cross-examination need not be confined to the facts to which the witness testified on his examination in chief. Then section 139 also speaks about cross-examination of a person called to produce a document. So we call him a production witness. If something is called from the bank, some bank statements, or from the mobile company, so he is a production witness. So he merely produces the documents. A person summoned to produce a document does not become a witness by the mere fact that he produces it, and cannot be cross-examined unless and until he is called as a witness. Then we go to section 165, the judge's power. That is, in future, it will be your powers to put questions or orders or order production. The judge may, in order to discover or to obtain a proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to examine any witness upon any answer given in reply to such question, provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. So thus section 165 of the Evidence Act confers vast and unrestricted powers on the trial court to put any question he pleases in any form at any time to any witness or to the parties about any fact relevant or irrelevant in order to discover the relevant facts. So even if any such question crosses into irrelevancy, the same would not transgress beyond the contours of the power of the court. Now, having understood what cruelty is, what are the provisions of the Indian Evidence Act, how they are to be applied, we'll take a case study. Now, the petitioner and the respondent, petitioner husband and the respondent wife, both are doctors by profession. The petitioner files a petition for divorce on the grounds of cruelty. They were married in or about the year 2017. At the time of marriage, the husband's age was 30 years, wife's age was about 28 years. The husband belongs to Mumbai, the wife belongs to Madhya Pradesh. It is an arranged marriage. The petitioner files a petition after about 4 years of marriage, when it becomes impossible for him to tolerate the behavior of the respondent, as there is physical assault on him, as also there is a constant mental stress and tension. So in this given petition for divorce, the petitioner husband has narrated the incidents that have transpired since after the marriage, that is 2017, and what was the conduct of the wife. It is like a script of a movie when you draft a petition, as it has to be in details. There is no scope for afterthought. Therefore, at the first instance, when you file a petition, all the incidents which has brought you to this decision of filing the petition has to be narrated. What is against you in a particular case has to be dealt with in the petition itself, taking the bull by the horn. If some incident is against you, deal with it right in the petition while drafting. Another aspect also is that you cannot take the other side by surprise. Therefore, when you file a petition, the other side gets a chance to file a written statement. And therefore, whatever you want to say, you have to say it in the petition by way of incidents. You have to narrate the entire conduct. Now, taking the case further, after marriage, both of them came to reside with the husband's parents at Dadar. The parents of the husband were also doctors. They welcomed the respondent with open arms and treated her like their own daughter. It is the case of the petitioner that the wife, that is the respondent, never tried to become a part of the family of the husband. She wanted to stay separate from the parents, and for this purpose, she created issues on every small aspect in the house. Her conduct while they were staying together with the parents of the husband is very relevant because it is directly directly related to the fact that she wants to stay separate, or she wanted to separate the husband from his parents, and therefore she created a terrible atmosphere in the house. All this impacted the matrimonial relationship between the husband and wife, as also the relationship with the in-laws. The entire atmosphere in the matrimonial house was vitiated, if one can use that word. Continuing further, the wife would be constantly instigated by her parents over the phone. The parents of the wife, instead of putting any sense in her to adjust in the new family, would give her ideas every day to make the life miserable of the husband and his parents. Now, the fact that the wife never bothered to be part of the marriage ceremonies of the sister of the husband is relevant in the scheme of things to prove cruelty. In fact, she created such a situation that the marriage of the sister of the husband was about to be broken. All this conduct is relevant to the fact in issue that the petitioner has been treated with cruelty by the respondent. Taking it further, the husband and his family members tried to make the respondent what they have done for her. That also has to be narrated. What good things they have done for her, and in spite of doing all this, this is her conduct. They tried to make her comfortable in the house and tried to adjust with her in every possible manner. Those instances are also narrated, which are showing how they adjusted, how they appreciated her work, how they appreciated her in every aspect. How the mother of the petitioner would give her tiffin, or how after coming home the food would be kept ready, etc. Now, all these facts are necessary and relevant to each other, connected to each other. These facts are connected to the fact of cruelty because these facts show what the petitioner and his family members have done. All this has to be narrated by the petitioner in his oral evidence. Now, the petitioner, he has suffered at the hands of the respondent. He knew that it may not be possible, or he may not be believed by the court to prove his conduct if he decides to file a petition. The respondent would constantly create a ruckus, would be screaming, abusing the petitioner, and her behavior would be uncontrollable. There would be in the morning, if she is okay, by afternoon, there would be a complete change in her behavior. So, or at times, the entire ruckus would start in the morning and would go until afternoon. So, the entire drama, as we call it, it would start in the evening, would sometimes end at midnight. This conduct of the petitioner husband at a time of festivals, of buying some gold, this is also a good conduct, which shows that in spite of humiliations and insults, he still tried to make the marriage work. Now, the petitioner husband, in this given case, it could be vice versa. It could be the respondent wife, the petitioner wife also. I'm just taking it as petitioner husband for this instance, who was seriously alarmed by the conduct of the respondent when it came to his knowledge that she was defaming him and his family members in the society by saying many negative things about she being assaulted or physically being harmed. He tries to gather the evidence which would help him in the legal matter. The petitioner and his parents, who are the owners of the house, they put a CCTV in the house, not in the bedroom, but in the hall and in the kitchen, so that there is some safety for them. So this entire conduct of the respondent wife on a day-to-day basis gets recorded in the CCTV. When the matter goes for trial, the footage of the CCTV, which is a documentary evidence, might help in proving cruelty. Of course, when this footage is produced before the court, or there could be recordings on the mobile phone. All those electronic evidence has to satisfy the parameters of electronic evidence and how electronic evidence has to be taken into consideration by the court. The 65B certificate is also important if any recording is there in the mobile phone, voice recording, video recording, then also the original mobile phone has to be given. The original device has to be given and a 65B certificate has to be given. The transcript also has to be given. If there are any emails exchanged between the parties recording this conduct or recording the conduct between them, then also a 65B certificate has to be given. So now in this particular case, the burden of proving that the petitioner has been treated with cruelty is on him. He therefore has to step into the witness box and depose as to what has happened or transpired in his married life. His oral testimony, which consists of the various instances that have taken place, good or bad, positive or negative, and what he has done to save the marriage. How he and his family had endured a terrible reprehensible conduct of the respondent, all that is narrated by way of examination in chief. The witnesses of the petitioner can also depose about the conduct of the respondent. If any independent witness, like a friend or a neighbor, is there, they can also be examined. The documentary evidence has also to be annexed or produced along with the examination in chief. The documents get marked at the admission and the denial stage, then the matter proceeds for cross. After the petitioner closes his side, the respondent steps into the witness box, her evidence and the evidence of the witnesses. So now the court has to test, the entire evidence comes before the court. The court has to test the evidence on the test of probability, whose truth is more probable, because it is a preponderance of probability. If there is a consistent narration of what has transpired in the matrimonial life, then the cruelty can be proved. In the petition based on cruelty, the instances should not be such that the court comes to a conclusion that it is a normal wear and tear of a married life. Of course, as earlier I have said, cruelty differs from person to person and it is dependent on facts of each case. It depends on various factors, but still for a court to come to a conclusion that the petitioner has been treated with cruelty, the court has to come to a conclusion that it is harmful or injurious for the petitioner to stay with the respondent. The court also has to come to a conclusion that the petitioner is not taking advantage of his own wrongs. Another instance would be if there is a case filed by the wife on the ground of, say, physical cruelty. She can have documentary evidence in the form of police complaints, FIRs, complaints to the Social Security branch. There could be medical reports of government hospitals or private doctors of any injury that has been caused to the wife in a given case. There could be a testimony of doctors, that is an expert witness in regard to the medical condition of the petitioner or the respondent, which would help in proving cruelty. So cruelty, which is necessary for passing the decree of divorce, has to be gathered from the evidence on record. The instances has to be clubbed together and a reasonable inference has to be drawn whether the behavior of the spouse comes under the term cruelty or not. Thus, we have seen how we can prove cruelty in a petition for divorce, which is the most common ground in a divorce petition in the family court. Again, as I said earlier, and as the apex court has held, there cannot be a straight jacket formula and it has to be derived from the facts of each case. So this is how a petition on the ground of cruelty, which is the most common ground under the matrimonial law, which is most commonly used, how cruelty can be proved in a matrimonial court, and the provisions of the Indian Evidence Act, how they are to be applied, we have seen. Lastly, I can say that I wish you all success for your exams for the family court judges post. We need really good judges who can lessen the pain of the litigants who come to court with so much hope. Thank you.
Thank you, madam. On behalf of Bar Council of Maharashtra and Goa, I would like to extend my heartfelt thanks towards our today's guest, Honorable Advocate Shilpa Joshi, madam. Madam, it was a very informative session and it will definitely help all our participants from the exam point of view. I would like to extend my gratitude towards Chairman, Vice Chairman, and all the esteemed members of Bar Council of Maharashtra and Goa. I would like to extend my special thanks towards our Vice Chairman, Dr. Uday Varunzekar, sir, for organizing this lecture series and who is also a coordinator of this lecture series. I would also like to extend my thanks towards all the participants who have participated in this lecture series. Thank you each and everyone. Now I would request the Sharath sir to conclude the lecture for today. Thank you, madam.
May I say one more thing?
Yes, madam. Yes, sure.
I'm really thankful to Dr. Uday Varunjikar and Sangram Desai and Shabnam Kazi for giving me this opportunity to give this lecture on cruelty and the Indian Evidence Act. And it was a really nice thing for them to allow me to speak on this topic. I'm really thankful to Dr. Uday Varunjikar.
Yes, sir. Thank you. Thank you, madam.
Yeah.
Yes. I would request Sharat sir to conclude the lecture for today. Vishwas sir.